Good evening, everyone, and welcome. Glad you're here tonight for a very special presentation. I'm Patricia Schechter. I'm professor of history, and I'm this year's chair of the Holocaust and Genocide Studies Project at Portland State. HGS is an affiliate of the Portland Center for Public Humanities, and our charge is to bring together faculty and students who have an interest in global themes like war crimes, genocide, the Holocaust, and mass murder, but we lighten the mood by also focusing on human rights. And we do this work across campus and across the city in order to foster learning and dialogue and awareness. And we often do so in collaboration with community groups who have similar interests. And I'd like to note the Oregon Holocaust Resource Center and the Cambodian American Community of Oregon, some of whose past and present leadership is with us tonight. I want to thank people for being here. Our next event with HGS this term is a film series exploring the connection between genocide and Native North American history, and there's some flyers with details on that three-film series out front. So please I'd like to encourage you to pick a flyer up, and hope you'll take advantage of those opportunities. A few thank yous are in order. I'd like to first thank the Portland Center for Public Humanities and Michael Clark for their support of tonight's event. Also the Division of Political Science from the Hatfield School and the chair there who's here with us tonight. Thank you for coming. And I'd like to thank Nathan Cohen, faculty emeritus in the English department, whose vision and funding is behind HGS. And I'd like to also thank Tavi Gupta, who's been our stalwart student administrator and advocate for the program. In addition, I'd like to thank International Studies, Criminology, and Criminal Justice, and leaned on the laptop here, for helping us get the word out about the event. I know a lot of students are here from those programs. So now on to our speaker. It's a great pleasure to introduce David Cohen tonight. Professor Cohen comes to us from the University of Hawaii at Manoa, where he teaches at the Richardson Law School. He trained in classics, graduating undergraduate from Occidental College, and he earned a JD at the University at UCLA, and then trained further in ancient history, getting a PhD from Cambridge in the 70s. Since the late 1970s, had a long tenure at Cal Berkeley, and he is truly an international scholar with a very a deeply humane vision of research and education and advocacy. And since the early 90s, Professor Cohen has trained his lawyerly eye and ethical compass on the issue of post-conflict justice in cases of severe human loss and human rights violations. Some of that work began in Europe and in the 90s, and he has been a great institution builder as his work has taken him across the globe. He founded the Documentation Center for War Crimes Trials at the Max Planck Institute for European Legal History in Frankfurt, Germany. In 2000, Cohen and a colleague established the War Crimes Study Center at UC Berkeley, which boasts an innovative digital component called the Virtual Tribunal, which is an online resource packed with primary source documents from all around the world, including Sierra Leone and Cambodia, parts of the world that I have an interest in. In recognition of his many accomplishments, Professor Cohen has recently been named director of the WSD Handa Center for Human Rights and International Justice at Stanford University. He has special expertise on East Timor, after violence erupted there in 1999 after independence. And in 2006, Professor Cohen published Indifference and Accountability, the United Nations and the Politics of International Justice in East Timor, which was based on his work with the UN Special Panel for Serious Crimes in that country. And that's the book that's on sale outside of the book table. So if you're interested, please take a moment to pick one up on the way out, where you can also sign up to get HGS emails and updates on future events this year and beyond. And again, I want to thank everyone for being here, especially Professor Cohen. So please join me in welcoming him to the podium.
Tricia, thank you very much for the kind introduction and for the invitation to be here. And it's great to learn about the program on Holocaust and genocide studies and the projects on Cambodia that you're doing here at PSU, and I hope to learn more about them. I'm going to be talking tonight about testimony and accountability, witnessing, observing war crimes trials, and truth commissions. One of the things that my center does is to monitor trials. When we started out, I was the one doing the monitoring, which I did in East Timor from 2000 to 2005, and in Indonesia at their Human Rights Court in 2002 to 2004. As the center expanded a bit, we started a trial monitoring program at the Special Court for Sierra Leone. It's a UN tribunal dealing with accountability for the Sierra Leone Civil War. And we had a trial monitoring team there from the first day of the first trial for the next 9 years through the end of the Charles Taylor trial. And then since the very beginning, in fact, the first day that the court moved into its offices in Cambodia, the Khmer Rouge Tribunal, we've been working there, and we've had an international monitoring team of young Cambodian lawyers, young Cambodian interns, and young students from the United States, Germany, Switzerland, Indonesia, Singapore, China, and elsewhere who have participated in our trial monitoring program that is still ongoing there. So that's where the witnessing part comes from, and I'm going to be talking about the search for accountability for mass atrocity tonight. So what I want to do is begin by giving you a sort of brief overview of what I would call the landscape of international justice. It's a very varied landscape, I think much more so than many people imagine. The range of the kinds of institutions that deal with trying to provide accountability for mass atrocity is very wide indeed. There are national institutions, international institutions, and within the international institutions there is a huge range, as you will see. And I think it's important to understand that sort of background in order to understand some of the problems of accountability that arise in these justice processes around the world. So we're going to start with that, and then I will sort of move on to talk about where we are today in the search for accountability. We're at a very critical juncture today. One era is ending, and it's uncertain how the next era will develop, and that'll be sort of the second part of my talk. So being a historian, like Patricia, let's go back to the beginning. And the beginning of the search for international justice is in this room, which is in Nuremberg, and that is the International Military Tribunal at Nuremberg, the first international criminal court that was created in the aftermath of World War II. And shortly after, it was joined by its Asian counterpart, the International Military Tribunal for the Far East, better known as the Tokyo Tribunal. Because of the politics of the Cold War and various other things, it was half a century before the next International Criminal Tribunal was created, which was for dealing with the conflict in the former Yugoslavia, the war in Bosnia in particular. And that is this building. This is the building of the International Criminal Tribunal for the former Yugoslavia. It's located in The Hague, which the Dutch government likes to call the capital for global justice, and very, very heavily financially supports any tribunal located there. You can see this is an imposing building. It's gigantic. It's a labyrinth. At its height, it's sort of downsizing now, this tribunal had 1,200 full-time employees and an annual budget of $170 million a year. This is downtown Dili, East Timor, in 2005. It's a rather different setting than The Hague. And this was the courthouse, which was lent to the UN. Tribunal de Recurso is Portuguese. It means the appeals court, but in fact, this was both the appeals court of the country as well as the site of the trials in East Timor. This photograph I took in around the 15th of May 2005. This is the last day of the last trial of the 55 trials held in East Timor by the United Nations. And one thing that's important to realize about that big building I showed you in The Hague, about this courtroom, these are courts that are created for one specific purpose, and at a certain time, they're gone. They're ad hoc tribunals. They're not permanent. Governments lend them buildings, and when they take back those buildings, as will happen with the ICTY in a couple of years, or happened 5 days after I took this photo in East Timor, there is no more court. There's no more physical structure. The people are gone. It's gone. This is this sort of armed compound that you see is the UN headquarters in Dili, East Timor. These are the handprints of the people who worked in the prosecution office. This is in the canteen of the prosecution in East Timor. It was a very emotional experience for everyone who worked in East Timor, some more positive, some more negative. And when people left the prosecution, they wanted to leave their imprint, literally. Essa Fall went on from Timor and is now a very distinguished international prosecutor at the International Criminal Court, etc. The day after the UN turned over this building in May 2005 to the Ministry of Agriculture, they painted this wall. And that was the end of that memorial. This is Cambodia. And that building is one of the two buildings of what the Cambodian government calls the ECCC, the Extraordinary Chambers and the Courts of Cambodia, and which the United Nations calls the Khmer Rouge Tribunal. Among other things they couldn't agree on, they basically couldn't agree on a name. That is the courtroom building. This is the administration building. This building was lent to the court by the Cambodian Armed Forces. This building was built along with another one that you can't see over here to be the headquarters for the generals of the Cambodian Armed Forces. And this building was to be the theater. Why the generals needed a theater that could accommodate 500 people is a question I asked but never got an answer to. But it did make for a good courtroom, a very large courtroom, the largest of any of the tribunals. So you have, because of the support of the Cambodian government, you have a quite imposing and good physical infrastructure at this court, very different than what you saw in East Timor. This is a screenshot from our TV show about the court. That's one of the paintings done in S21, or Tuol Sleng, by one of the detainees. This was the chief torture and interrogation center of the Khmer Rouge. One of the detainees was an artist, and he was commissioned to make paintings of what happened there. This is a screenshot from our weekly TV show from the first trial, Doik on Trial. This is the site where the Cambodian national trials took place long before the UN ever came to Cambodia. These trials gave perhaps a new meaning to the word show trial because this is the national theater of Cambodia, and that was the site that was selected in 1979 to conduct a trial in absentia of Pol Pot for genocide. And that is the scene in the courtroom during this rather short trial of Pol Pot that he was not present at. When the UN was looking for a site for the new Khmer Rouge Tribunal, they initially focused on the National Theater. They fortunately decided, because of security concerns, not to have it there. They didn't seem to be aware that having a trial in a theater might not be the best starting point for a tribunal. We move a continent away to Africa, and this is part of the entrance of the Special Court for Sierra Leone. Because that court was located in the country, it was created by the United Nations at the request of the government of Sierra Leone following a very vicious 12-year civil war. The court, as you can sort of see here, was an armed compound surrounded by a very large security fence with watchtowers, with Nigerian troops with machine guns. In the towers, there was an armored personnel carrier or a tank parked in front of the detention center within the compound 24 hours a day. Fortunately, there were no real security concerns. The gentleman on the left is a Nigerian soldier working for the UN. This is the courthouse in Sierra Leone. A little bit different than the structure that you saw in East Timor, and that's because the United Nations decided to invest, I don't know, $15 million in building a courthouse, which the government of Sierra Leone told them from the very beginning they could never afford to maintain and would never use. An alternative was to remodel the existing beautiful colonial-era building in downtown Freetown, which is still used by the Sierra Leone judiciary, and would have given it a renovated facility. However, again, for security concerns, the UN decided to create its own compound with this court in the middle. By the way, all the other buildings were shipping containers. So it was kind of an odd contrast to be in this compound where the prosecution, the defense, the administration, the judges were sitting in shipping container offices, but the trial was taking place in this building, which in fact the government cannot afford to maintain. This is the interior of the courtroom. You can see a quite different setting from what you saw in East Timor. It was equipped with all of current IT, simultaneous translation, so on and so forth, none of which you had in Timor, even though the same organization was running the two courts, the United Nations. Just to give you an idea of the order of magnitude, as I told you, at the time this trial was taking place, the budget of the Yugoslav tribunal was around $170 million a year. The budget of this tribunal was around $29 million a year, and the budget of the East Timor tribunal was $6 million a year. And that was not due to the number of cases. In Timor, they tried 55 cases. In this court, they tried 4. To put a human face on this, these are our trial monitors, our first group of trial monitors at the special court. It's Michelle Staggs, who was a Malaysian lawyer doing international financial law in a big international firm until she had the misfortune to meet me. And then 6 months later, she was in Sierra Leone. Her parents have still not forgiven me for that. Next to her is Penelope Van Tile, who's also in the picture on the left, and was a Berkeley law student at the time and has then worked with me for the last 7 years. The reason the two of them are so happy is they had just moved into our office at the court, where the witness protection and unit actually provided an office for us. And Penelope is with 2 of the Nigerian security personnel for the court there on the left. These are Sierra Leoneans at a community outreach meeting where Sierra Leone had the most innovative program at the time to try to make what was going on in the court meaningful to the people of Sierra Leone. If we talk about accountability, if we talk about witnessing, if we talk about all these things, who is supposed to be the recipient of the benefits? When you have a court in The Hague, many thousands of miles away from Sierra Leone or Congo or Darfur or whatever, How is that supposed to be meaningful for the people there? This process is what the courts call community outreach, or the outreach function of the court. Sierra Leone was the first court to take that really seriously. In 2000, it was either in about, was it 2003? Anyway, around in 2000 or 2003, the first survey, population-based survey, was done in Rwanda to determine how many Rwandans were aware of the work of the International Criminal Tribunal for Rwanda, located across the border in Arusha, Tanzania. 93% of those interviewed said they had either never heard of the court or they had heard the term ICTR but had no idea what it was. That's the problem of outreach. It's extremely difficult in a country like Cambodia, like Sierra Leone, to do outreach. Only a small part of the population has access to television. Only a small, an even smaller part has real access to print media. So that court was one of the most innovative. And today, the court that has really taken the lead and gone far beyond what anybody else has done in outreach is Cambodia, is the Khmer Rouge Tribunal, that with the help of both international partners, we're one of the international partners, local NGOs, and so forth, has developed an extremely broad and effective outreach program that has had a huge impact on Cambodians' understanding of their past and the work of the court. That book, by the way, that he's holding is a sort of cartoon, illustrated book about the court, because many individuals in Sierra Leone are illiterate, and giving them some learned treatise on the court would not explain anything to them. Now, this is actually a video clip, and I'm not sure how to make this work on this. Okay, it doesn't. In any event, I was going to play a 60-second video of a sentencing, and this is another one from the ICTR, but we won't have that. So we go from the courtroom with robes and security personnel and so forth of the International Criminal Tribunal for Rwanda, which at that time, let's say, had a $100 million a year budget and has cost us international taxpayers over $1 billion since it was created. I'll tell you in a little while why I keep talking about money. And now we go to Rwanda itself. This is a Gacaca court. Stephanie Cheng was one of my students in Berkeley who monitored Gacaca, the very gifted photographer, and did an exhibition in San Francisco of her photographs. They are putting together the courtroom for a kind of people's court, non-professional judges, no lawyers, in which about 200,000 Rwandans were tried for their role in the Rwandan genocide. These are the judges of a Gacaca court. There was a court in every village, and there was a 3-day national training program for the judges. So these are villagers, probably none of whom finished high school, and received 3 days of training before becoming judges in genocide cases over their fellow citizens. This, on the other hand, is the International Criminal Court in The Hague, a rather imposing structure. This is a courtroom in the International Criminal Court for The Hague. Now, you may think this building looks nice, but this is actually only the temporary headquarters of the ICC because they felt this is not adequate for their institution. And this is an architectural sketch which the ICC has created of the future site of the ICC, International Criminal Court, which is a whole compound of very nice buildings. That's the landscape. And this institution, the ICC, is the future, or is supposed to be the future. Why is that? That brings me to sort of the second part of what I want to talk about with you. As I said before, all of these courts that I showed you are temporary. All of them, with the exception of the Special Tribunal for Lebanon, which can't get any defendants in its custody, are in the process of closing down. Either they're already gone, Timor, Sierra Leone, or like the Yugoslav Tribunal, the Rwanda Tribunal, they are in their closed down phase. Within 5 years, the Cambodia Tribunal will be closed, the Rwanda Tribunal will be closed, the Yugoslav Tribunal will be closed, the Special Tribunal for Lebanon will be closed, and that's it. Those are the only ones, except for the International Criminal Court. So we're at a very critical juncture in this 60-year, 70-year trajectory from Nuremberg to today. We've just experienced 20 years of innovation. How do we create institutions that can provide accountability and conserve the interests of the population of a post-conflict society in obtaining justice? And then there's lots of other things that the UN promises: reconciliation, closure, healing, on democratization, the rule of law, etc., none of which it's terribly interested in delivering in terms of really putting their actions where their mouth is. What these courts have been good at doing is prosecuting. That's what they're really set up to do. And whenever you talk to the UN or the country donor committees that provide money about things like outreach, they go, outreach is not your job. Your job is prosecuting. Your job is convicting war criminals. All of the outreach work done, for example, in Sierra Leone, was externally funded. Not a penny came from the UN budget. For the first 4 years in Cambodia, the UN said, don't talk, the donor committee, the UN said, don't talk to us about outreach. You're not here to do outreach, you're here to prosecute. That raises the question of how do you make accountability meaningful if the people of the post-conflict society have no idea that it's taking place? It's great to put war criminals in prison. That's a large part of why I work on what I work on. But if you want to have an impact on the people who have suffered mass atrocity, you have to make this justice process, which is complex and largely incomprehensible to anybody who's not a legal expert, meaningful to those people. And that's the other side. That's the other side of accountability. So we're now at a point where, for the advocates of the International Criminal Court, this is the future. The very strong constituency of international lawyers, international organizations, international human rights groups, and so forth that have been pushing for the creation of the International Criminal Court, which came into being in July 2002, they saw that as a fulfillment of the dream of Nuremberg. Nuremberg was supposed to be the first, not the last, International Criminal Tribunal. It was supposed to, along with the creation of the United Nations that happened at the same time, and the United Nations War Crimes Commission that was also created at the same time, they were supposed to provide a new framework for international justice. And an important component of that framework was supposed to be the creation of a permanent international criminal court. Because of the way that the Cold War developed and impacted the politics of the United Nations, that never happened. It didn't happen until July 2002, when this institution was created. So we now have that permanent court. but it's there in The Hague. Its cases are in Sudan, Kenya, Central African Republic, Congo, Libya, Uganda, and I'm forgetting two others. They're all in Africa. And that's the meaning behind this poster, is the ICC targeting Africa. Because every case that the ICC has brought forward to indictment is from Africa, you're now getting serious pushback from African governments and institutions, especially because of the decision of the ICC to prosecute the president and vice president of Kenya for their role in the election violence a couple of years ago. So the challenge for the ICC is, first of all, how to provide accountability at all. In the 12 years since it was created, it's completed one trial. That was of a Congolese warlord, one individual, Mr. Lubanga, who was charged with only one crime, which was recruiting child soldiers. So that's the track record of the institution that's housed in this big, beautiful building and has a budget of about $100 million a year. Beyond that issue about can the ICC succeed in actually bringing people to trial and completing trials, which is necessary for accountability, then there's the issue of what do people in Congo or in Central African Republic or in Uganda know about what's going on in The Hague? If you go to the website of the International Criminal Court, you will see all sorts of information about their outreach program, and they spend a lot of money on outreach. They get a lot of funding from the European Union for outreach. You will find, for example, that they do events or programs like bringing Congolese journalists to The Hague for intensive training on how to report on the trials that are taking place, like the Lubanga case involving Democratic Republic of Congo. If you read the fine print, you will find that the 8 major newspapers represented by that group of journalists, those newspapers had a total circulation of 13,000 people in a country of whatever, 40 or 50 million. Print media is not effective in Congo. You have some really dedicated people, a woman named Wanda Hall, who's been setting up micro radio stations in conflict areas of Congo, in eastern Congo, under often very dangerous conditions. Incredibly innovative, really great program. But again, how many people does it reach? Do the people of Congo feel a sense of ownership for an institution that is in a European country that they've never seen, that they don't know anything about, and that is exclusively run by people who are not from their country? So it's one thing to convict war criminals, it's another thing to make that process meaningful. And my sort of position on this is, if you're going to be effective, you need to do both. You can't do just one. So why was I harping on budgets and money so much? Well, one thing is that it reflects the differing commitments of the international community as sort of filtered through the UN and the Security Council to conflicts in different parts of the world. Why did the Special Panels for Serious Crimes in East Timor have a budget of $6 million a year at the same time that the Special Court for Sierra Leone had a budget of $30 million a year? Well, it's just because East Timor is a tiny country that nobody cares about, to put it really bluntly. And that is reflective in the way that the process was not only resourced, but in the utter failure of the United Nations to meet even minimum fair international trial standards in Timor. In my first visit to Timor in late 2005, I interviewed the head of the prosecution, a man named Mohammed Chande Atman, a distinguished career before and since, and I asked him, as the head prosecutor, do you have an obligation for this court to meet basic international fair trial standards? It was sort of an interviewer's or investigator's dream because he gave me a straight answer. He said no. Quite astonishing to a man wearing a UN identity card around his neck, sitting in an office flying a UN flag with UN stationery all over his desk. But he just said no. And I said, well, then what is the standard that you have to meet? And he sort of gestured towards Dili and said, local standards. There were two things that were rather disingenuous about that at the time. First of all, there was no justice system. And you can believe me that even today, after 14 years of legal reform, there's a justice system that doesn't remotely meet international standards. And second, the UN was the government of the country at the moment that he made that statement. He was working for the United Nations Transitional Authority for East Timor, which was the government of East Timor from 2000 to independence in 2002. East Timor was not an independent country when he made that statement. It was the United Nations that had set up the court system and was running it with UN personnel. So to say, well, oh, local standards, well, the UN were the local standards, unfortunately. In Cambodia, we have a very different picture. The Cambodia Tribunal, the Khmer Rouge Tribunal, the ECCC, has been heavily criticized by international human rights organizations for things like political interference of the government and so forth. There are different views on that. I actually think that a lot of the criticisms that are being made are unfair for a variety of reasons. I'd be happy to discuss them in the discussion. But what has happened in Cambodia is that you have had trials that have met international fair trial standards. Whatever is happening outside the courtroom, what is happening inside the courtroom is a fair trial on basically every measure that we use for measuring fair trials. So we have a very wide range of attempts. I think the best way to understand the last, I'm very bad in math, 21 years since 1993, when the Yugoslav Tribunal was created, is what we've seen is a series of experiments. Different kinds of courts of different size with different mandates. In East Timor, they were trying basically only low-level people. The trend later, having learned from that, in Cambodia, was the court only has jurisdiction over senior leaders or those most responsible. The jurisdiction of the Special Court for Sierra Leone was limited in the same way, and it's a policy of the International Criminal Court to only go after high-level people. These trials are incredibly expensive. They're incredibly long, very technical, and so forth. And what they dispense, and this gets us back to accountability, is always going to be a kind of symbolic justice. Nothing else is possible at the international level, just as it wasn't at Nuremberg. The Allies, when they occupied Germany, made a list of 5,000 major German war criminals that they wanted to put on trial. There were 23 at Nuremberg. And in the subsequent so-called 12 subsequent proceedings at Nuremberg that lasted for 4 years, there were 119. That's actually a lot. If you're doing these kinds of trials rather than sort of summary, I mean, it's easy to convict people. The question is, are you having a real trial? Going backwards. This is not a real trial. You can convict lots of people this way. But are you doing justice, and is that accountability? That's the question you have to ask yourselves. So where is the balance between this and that? That's the ongoing experiment. And what everybody knows sort of in the world of international justice is that these big tribunals are too slow and too expensive. What to do about them is another question. So the experiment was, well, let's try to have a court in Cambodia that's part Cambodian and part international. Let's try to have a court in Sierra Leone that's part international and part national. Well, then you just get into all sorts of other problems, and the most basic one is everybody wants to set it up and nobody wants to fund it. So the Cambodian court has gone from one series of financial crises to another. We had a strike in 2013 by court personnel when they walked out because they hadn't been paid for 5 months. Why weren't they paid for 5 months? Because there was no money. Literally, there was no money. We had another strike in 2011 for the same reason, because there was no money. In Sierra Leone, I was talking to the registrar of the court. That's the CFO of a court, the registrar. I was talking to her, her name's Binta Mansarai, and we were talking about our virtual tribunal project. And she said, David, I really want to talk to you about the project and about how we're going to get funding, but I have to tell you the electricity bill for the court is due in 10 days and I don't have any money to pay it, and they're going to turn off the power. That's also the reality when you move from that level out in the field in Cambodia, Africa, East Timor, to the world of The Hague, where they don't have to worry about those things. So, and then I want to end with a completely different question, and it's a very troubling one. It's one which I expect some of you to raise, so I'm going to anticipate it. And that is the question of when you're dealing with some of the poorest countries in the world, East Timor, Sierra Leone, at the end of the violence, were among the 10 poorest countries in the world. You're dealing with post-conflict societies in which families have been torn apart, tens of thousands, hundreds of thousands, or millions of people, as in Congo, it's millions, have been killed. Tens of thousands of women have been raped. Millions of people have lost their homes and now live in a different part of their country or abroad as refugees, and the country needs to be rebuilt. Is this the best place to put the resources? I'm not going to answer that question. It's a very difficult question, and I certainly don't have an easy answer. But I just want to close with a juxtaposition between the world of The Hague, with this vision of this grandiose, fantastic, huge compound of structures, and the world of the people who are supposed to benefit from the process that takes place there. That's Kenya after the elections. Communities being burned and tens of thousands of people losing their homes. This is a village in Darfur, another one of the court's cases that has been destroyed. And even before it was destroyed, you can see it's a little bit different than The Hague. And this is Eastern Congo, refugees on the move. Over 3 million people who have been killed in the conflict in Congo over the last 10 years, hundreds of thousands of them in movement from all the various rebel groups, militias, and so forth in their country. And I think those are, I think, the two great questions that we face today is, what is the future of international justice? Is it in the International Criminal Court? Or should we be working to build national institutions, to invest the money not in the very luxurious salaries and the very beautiful buildings and so forth of the people who work in The Hague? Should we be investing that in trying to assist governments like those of Uganda or Kenya or Congo or Cambodia or wherever in building up their justice system by working with them through a cooperative venture? And that's the question I'll close with. Thank you.
Take a few questions.
Be happy to.
The floor is open.
Who does or doesn't recognize the authority of the International Criminal Court? I mean, does the United States recognize the authority of the court?
Well, there's an easy answer and there's a complicated answer. The easy answer is no. The International Criminal Court is a treaty-based organization. That means it was created by an international treaty that countries ratify. It came into being in 2002 because a sufficient number of countries had ratified, and now, I'm not sure the exact number, somebody probably knows, it's about 130 countries that have ratified. China has not, the United States has not, India has not, most Southeast Asian nations have not, so a lot of the major powers have not, and that's because they're the ones who engage in the kinds of military operations where they're concerned. That's the easy answer. The other answer is more complicated because the United States has a very complicated relationship to international justice. On the one hand, we don't ratify the ICC treaty. On the other hand, we are the major financial supporter of most of the courts that I've shown you. The major contributor to the Yugoslav Tribunal, the Rwanda Tribunal, the Special Court for Sierra Leone, and a very important contributor to the ECC in Cambodia. We have a State Department war crimes ambassador and a war crimes office, and the State Department travels around the world ceaselessly promoting accountability, working with national governments and international institutions. When I was at in Kampala, Uganda, for what's called the Assembly of State Parties of the International Criminal Court, a couple of years ago, which was a major review session for the court, considering some very important issues and so forth, there was a huge U.S. delegation there, very actively engaged in negotiations. Why? Because the big issue under discussion was whether or not to fully activate the provision in the charter of the tribunal that would recognize aggression as an international crime under the jurisdiction of the court. The United States, understandably, takes a very active interest in that question. So here you have a country that's not a member with a delegation, very high-powered delegation of about a dozen people, lobbying like crazy and engaged in all the negotiating sessions. So the United States has a bit of a schizophrenic attitude towards international justice and towards the ICC in particular, an attitude that has become more positive in the last couple of years, but not at the overt level. So, yes.
One of the driving questions I heard you ask was sort of, what's next for the ICC? What is the next model which may work better than the one that currently exists? And but I didn't hear you talk about the other power of the ICC, which is public opinion and the force that exerts when an individual has been charged with a war crime. And I think of Laurent Nkunda in Congo, of course, who was charged with crimes, and he continued to assert his authority, and eventually that international pressure around those charges, even though there wasn't a court set up to even extradite or to charge him formally in a court, eventually that led to his arrest, of course, by Rwanda. still to be determined his whereabouts, and so on. But can you talk a little bit about sort of how just the ICC functions using public pressure to limit criminals' actions once they've been charged?
Yeah, this is really a key question, one I didn't really talk about. It's a key question for all of the tribunals. I think there's two components to it. One is public pressure, but the one which is ultimately determinative of what happens is political will on the part of the UN Security Council. And more generally the United Nations, but particularly the Security Council and particularly the 5 permanent members of the Security Council. These courts have no direct enforcement capacity over arrests. They can sentence people to prison once they're in custody, and those people will be sent to prison. The courts don't have prisons, but they have arrangements with countries, and they farm them out to countries that they make contracts with. The problem is getting custody of these people, which the ICC has failed to do in Sudan, has failed to do with the Lord's Rebel Army in northern Uganda, etc. It succeeded in a number of other cases. But the enforcement mechanism to arrest and bring people into custody goes through, in the formal sense, through Interpol, International Arrest Warrant, but depends upon the cooperation of governments to actually do this. And that usually depends upon the willingness of major powers or regional powers to exert pressure on those governments. So, Bashir, the president of Sudan, has been under indictment for I forget how many years now. International arrest warrant issued for him, in 2007 or whenever it was. It's a long time ago. He travels all over. But he travels to countries that won't enforce the warrant, even though they're part of the Interpol system of international arrest warrants. But nobody can force them to enforce an international arrest warrant when he steps off the plane and onto the red carpet, because he's being greeted as a head of state. In the case of East Timor, I mentioned that in the 55 trials, there were 87 accused persons that were put on trial. Not one of them operated above the village level. They were all basically farmers who belonged to Indonesian militias and operated at a very low level, no significant rank whatsoever. Where were the generals and the colonels and whatever, both the heads of the militias, the Timorese, and the Indonesians who were directing them? Well, they were in Indonesia. Why didn't they ever appear before a court in Dili? Well, there were two main reasons. One is in 2002, a bombing happened in Bali, the Bali bombing of a discotheque in the city of Kuta that killed, I forget, about 180 individuals, mostly foreigners. That was regarded as an act of international terrorism by an Islamic radical organization with loose affiliations to Al-Qaeda. That meant that Indonesia became a strategic partner in the war on terror. So any political will that there might have been, which was not great to begin with, on the United States to really pressure Indonesia to cooperate with the UN process in Timor evaporated immediately. That was gone. At the same time, neither the UN nor the Timorese really wanted to bring those generals before the court for a variety of different reasons. And when General Wiranto, the commander-in-chief of Timorese armed forces at the time of the violence, was indicted, finally, and an international arrest warrant for him was issued, the UN in New York immediately issued a disclaimer. Now, how can you disclaim your own organization that's just issued an arrest warrant? But they did. And at the same time, the head of state of East Timor, Xanana Gusmao, who had been the charismatic leader of the independence movement, etc., he flew immediately to Bali, where he held a press conference with General Wiranto and embraced him in front of the cameras and called him my dear friend. The reason I'm telling you about this is not to blame these people or whatever, but the political will is everything in making these institutions work. And political will is politics. These courts are political creations. The ICC is not, it's a permanent court, but its operations operate in a complex political field that will determine who's brought into the custody of the court. Probably has something to do with why all 8 cases are in Africa, none in South America or Asia, where we might be able to think of some other conflicts that are either going on right now or have gone on, of at least a similar dimension to the post-election violence in Kenya in 2010. And I mean, I'm not saying this out of some deep-rooted cynicism, but that's simply the world that we live in. That's the kind of organization the United Nations is. It's the way international politics operates, and we're never going to be effective if we don't understand that. So, ultimately, these kinds of issues of accountability and of who can be brought before the courts and what cases are going to be brought forward and what cases are not going to be brought forward are going to be determined in part by these kinds of issues for better or for worse. Yeah.
I think you've answered most of the questions I could have asked you, and because they all overlap over each other, I won't ask more in the same time. But in that case, if the ICC only operates within a set of operations that depend on the political will of Security Council members who are themselves providing arms to most of the conflicts worldwide, what do you see for the next, let's say, 10 years as a glimmer of hope in a way that you can have some level of international justice, whether to the ICC or other organizations?
Okay, so you're asking me for my personal view.
Yes.
Okay. So my personal view is this. I hope, let's put it that way, I'm not the only person who hopes this, that there's going to be a recognition that we will continue to need these kinds of hybrid tribunals like the ECC in Cambodia or the Special Court for Sierra Leone that are located in the countries where the conflict takes place and will operate together with the justice system of those countries. In other words, my hope is that this is not the end of an era, and as the big advocates of the ICC say, okay, that's all done, now we're the only game in town, that there will be some cases that will be done by the ICC, but some where there'll be a recognition that, the ICC is not going away, it's there, it's a treaty-created organization. But there will be new courts created like that can provide better solutions. The second part is that, I think we will see more work with national jurisdictions to try to increase their capacity to deal with these cases within the national courts. And that's what the hybrid tribunals were supposed to do. The only country where there's two, where they've been effective in doing that is to some extent in Cambodia, and then much more so in Bosnia, because they created a court there that was designed from the beginning, called the Bosnian War Crimes Chamber, to phase out the international participation within a very limited number of years, so there would be a pure Bosnian court, which it is today. So the UN was sort of there in a kind of mentoring capacity programmed to disappear early, but for the process to go on. I mean, that's one kind of model. There will be other kinds of models, but ultimately, if you're really interested in accountability, on my view, you don't just put a few 80-year-old accused in jail and then walk away. I'm mentioning 80 years old because all of the Cambodians currently on trial are over 80 years old. We may get some younger ones in the next case that may or may not go forward. But they'll be in their, whatever, late 60s or 70s or something like that. What you have to do, and it's not that nobody recognizes, is everybody says it's a goal of these courts, but they don't really invest in doing it, is to build that national capacity to prosecute these kinds of crimes. And that is not an easy thing to do. These are incredibly difficult, complex cases to investigate and to try. They are not like any case in national criminal systems. Even comparing them with prosecuting organized crime organizations is, it's completely different. And it takes a lot of expertise and a lot of experience and so forth. And ultimately, it seems to me that what you want is for countries, when there is a political transition away from a civil war or a genocide or an authoritarian regime, is for those countries to have the capacity themselves to deal with it in a way that is nonetheless a real trial and meets fair trial standards. So that's, I don't know if I answered your question, but that's,
yes,
that's where I hope things go.
Yes, thank you.
Yeah.
Thank you. I'm wondering about the contribution from human rights groups, because, well, they set up fact-finding missions, right? They produce reports, they gather evidence, and since they rely on their credibility for their reputation, those reports, most of them look really meticulous, very technical, very specific, with a lot of forensics, a lot of expertise. And they've been advocating for this ICC project, right? But in that way, building putting so much effort in the whole process, what role for them can be in all of this?
Yeah, you're all asking all the right questions, which is why they're questions that we could actually spend 3 hours discussing. This is one of them. First of all, you have to distinguish between different kinds of international human rights organizations. Let's say the model of the International Crisis Group is very different than the model of Human Rights Watch or Amnesty International. International Crisis Group operates through in-country offices with people usually with a lot of experience, and they tend to write an ongoing series of very detailed, very well documented reports. Some of the big international human rights organizations that try to be global and cover basically every country are much spottier in the sense that they will understandably emphasize what's going on in some places and invest a lot of resources and be a lot, let's say, less meticulous in other countries. So, for example, when we were monitoring trials over many years in Sierra Leone, one of the international justice people from the small unit in Human Rights Watch who deals with the tribunals would come once a year, sometimes twice a year, for 5 days. The first thing she would do would be to spend 1 to 2 days with our monitors to catch up on what was going on in the court. And then she'd interview a couple of people, and then she would fly back to New York and write a report. The judges stopped giving interviews to Human Rights Watch because they were so incensed over the inaccuracy of the reports. Now, I'm not saying that's the way they operate in every country. They don't. In some countries, they produce extremely good, well-documented reports. But if you're operating globally and you're trying to cover as much as you're trying to cover, it's difficult. In International Center for Transitional Justice in New York, another very good organization with a narrower focus, let's say, than HRW or Amnesty, the two people who, they're both gone, but until a couple of years ago, the two people, both extremely capable people, who did all of the transitional justice work, each of them covered 14 countries. That's a lot. I'd say there's a range in the kind of work that they produce, and I think one difference between some of those organizations, let's say the crisis group, is that the crisis group is more interested in producing reports that are advocacy but will promote cooperation with, will get the government to do things, as opposed to what's called naming and shaming, which is sort of the way that some of the other organizations operate, which is great for their members, but not very effective. Because, and I can tell you certainly in many of the countries that I work in, those organizations just lack legitimacy. I'm not saying they're not legitimate, they are, but it's easy for the governments to dismiss them. I think it's quite complicated, and I can just tell you, and I won't mention any names of organizations, that I have been in situations a couple of times where when I was the one doing field work and I was having a conference call with several major international human rights organizations in another part of the world, where there were representatives from several organizations in the room, and we were talking, they told me that they were not happy with my findings. Not because they were inaccurate, but because they didn't suit their agenda. And I said, well, it's a very complicated situation here. It's not just black and white. And they said, sorry, we need black and white. We don't want gray. And I said, well, I'm trying to produce a balanced report. And they said, balanced report's not in our interest. So, and that's one of the things that people who are not so friendly to them point to for the issue of legitimacy. They say, well, this isn't balanced. What about this, this, and this, and this that was left out of the report? So, again, I mean, don't get me wrong. I'm not trying to badmouth these organizations. They're incredibly important. They are the major players in human rights around the world. And they have helped save the lives of a lot of people. They do an enormous amount of good. We're obviously better off having them than not having them. But we do have to realize in each case what kind of organization it is, what their goals are, how they do advocacy, and so on and so forth. So I don't know if that answers does that answer your question? Okay. Yeah.
Within the ICC as an organization, within the prosecutorial staff or the judicial staff, what's the attitude toward the hybrid approach or the local approach? Are they generally supportive of those developments? Do they collaborate? Do they help them? Do they share research? Or is there kind of a jealousy about whose turf it is?
I think jealousy is not right. That's because I think the ICC considers themselves to be so far above all of those other courts that, I mean, competition is not even on their radar screen. I think what's revealing is what seems to be the attitude of the ICC, of the judicial sort of part of the ICC, to the jurisprudence that's been produced by the other courts, particularly the Yugoslav Tribunal, which if they would see, I mean, that is an organization that is a rival organization. I mean, its size, its impact, it's been the Rolls-Royce of international tribunals since it was created, and it has produced a body of jurisprudence that has just completely revolutionized or changed the face of international criminal law, because it was the first and they have the biggest staff, the best judges, the best prosecutors, the best legal officers. They were all there. They were not, believe me, in Arusha or in Sierra Leone or in Phnom Penh or whatever. And so they've produced this huge body of jurisprudence. The attitude of the ICC, which everybody looks at, that's what everybody writes about. The attitude of the ICC seems to be, well, that doesn't concern us at all. We have our own charter. So we have to develop our own jurisprudence. And that's something that a lot of people regard as unfortunate. Because the way that international law develops is because there is no formal system of precedent or whatever, like in a national system, no organizing power. It's really the way that everybody looks at what everybody else is doing and learns from it. And so all the other courts, if you read judgments from Sierra Leone or from Cambodia, what are they citing? They're citing the other courts, particularly the Rwanda Tribunal and the Yugoslavia Tribunal. And so instead of sort of building on that, the ICC seems to largely be saying, well, none of that applies to us because we have our own statute, so we'll create our own body of law. Yes?
David, my question is sort of a hangover from our conversation earlier today about documentation, archives, and use of evidence. Could you say a little something about, and I was struck too by interest in the room in, whose words, whose evidence, whose documentation is sound, what is the place of outsiders versus insiders? Can you say a little something about either how the technological revolution or some urban-rural issues globally have maybe created some opportunities for average people to document and tell their own stories? Has there been a shift in either the legal wisdom and practice or the investigative, the journalistic side, the muckraking side, in how they gather evidence, who decides, and has there been any big changes in the places you've been in this sort of, how do you constitute evidence? Has there been any changes in the standards or gathering or legitimacy issues that we've been talking about tonight?
Do we have another 3 hours? Okay, I'll try to address some of those issues. One of, and I'm sorry I didn't mention this before, there was just a lot of ground to cover. One of the most important ways in which the Cambodia Tribunal has been innovative is in trying to create a much more central role for victims in the courtroom. And they were able to do that because the Cambodian Code of Criminal Procedure is essentially the French code based on the French colonial code of civil procedure. And it calls for an institution which is fairly unique to the French system, which is called civil parties, the parties civiles. And those individuals are parties in the technical sense, alongside the prosecution and the defense. So in theory, they have a right to question the witnesses, to make statements, so on and so forth. So, that's been a huge innovation. Let's just say, we would need a long conversation. Let's just say it proved extremely difficult to manage the reality of that, as opposed to the vision of about how wonderful it would be to bring the voices of the victims into the courtroom. It was a nightmare in terms of trial management, and the end result, through a very long series of changes in the internal rules of the court while the proceedings were going on, is that it's really the voices of the victims as represented by international lawyers who speak for them. Now, in terms of testimony, that's not true, because as witnesses, they appear and they testify. But in terms of being parties, it's a sort of mediated role. The ICC, International Criminal Court, calls itself the Victims' Tribunal. They have created a Victims' Trust Fund that will provide some kind of reparations or whatever. But again, what that actually means in terms of a court that's located in The Hague and so forth is something very different. And just going back to what I said before about Cambodia having the most innovative and effective outreach program, 60,000 Cambodians have sat in the courtroom for a day. I mean, you cannot imagine, what that means. If in a year of trials in Sierra Leone, and that court was located in the capital of the country, if in a year of trials there were 100 people in a year sitting in the courtroom, that would probably be about it. So 60,000 Cambodians from all over the country, literally every province in the country, have been brought to the court through a collaborative program between NGOs and the outreach unit in the court. So, it's a very difficult process to make that a reality, and you have to invest in it. You have to invest in it to do it, and you have to be in a place where it's possible. In regard to, testimony and all of that, for those of you interested in oral history, and I know that there's an interest in oral history in this institution, when you think about what the record of a trial is, apart from providing the judges with information to make a determination about guilt or innocence, it is, it contains, the story or the lives of all of the people who appeared before that court. I forget the exact number in Cambodia, but in the first trial it was certainly over 100, I think, altogether. Now, oral history documentation and oral history project is very different than testimony in court. One of the ways in which witnesses are often disappointed when they come to court is they think it's their chance to tell their story, and it's not. They don't get to say, I'm so-and-so and I was born here and let me tell you about my life, which is sort of what you do in some fashion or another in a typical oral history interview. They're asked questions, and the questions are designed to feed into certain aspects of the case that who's ever calling them, the prosecution or the defense, is making. But nonetheless, their testimony is there. And if you look at the video, and we have video of most of the courts, if you look at the video of people testifying in Cambodia about what it was like to be detained at the Tuol Sleng Detention Center, S21, or what it was like to be a guard there, or whatever other function they might have had, this is amazing testimony, and it needs not just to be preserved in some vault somewhere, which is what the UN's idea of preservation is, but rather it needs to be made accessible to people, and particularly it needs to be made accessible to audiences like this, but everywhere in the world, in Cambodia, in Portland, in Europe, in Africa, wherever, and that's where the IT component comes in. We have the capacity to do that now. It's just the courts are never going to do it. It's not part of their mandate. It's not what they have funding for. And it can only come through organizations that are willing to work with them and to make use of this documentary record that they create. If you combine that kind of documentary record together with oral history and other kinds of projects, you can create a really powerful historical documentation. And I should say that in Cambodia, one of the areas where Cambodian NGOs have been very active for many years is doing video interviews of survivors. In typical fashion, the different NGOs don't particularly collaborate and whatever. There's some very small ones that have been doing it. There's some very big ones that have done a lot. But together, there is a huge amount, hundreds and hundreds and hundreds of survivors have put their testimony on video. But that also needs to be made available and, be made meaningful. Again, the problem's not the technology. The problem is just money and organization, which are sort of the usual problem. So, yeah, yes.
What effect does peer-reviewed trials in absentia have on accountability, and why would the ICC not do them as optimistic?
Could you all hear in the back the question?
No.
Okay, it's what effect do trials in absentia have on accountability, and why would or wouldn't the ICC do those kind of trials? Okay. Okay, well, the first reason is, just the starting point, is that a trial in absentia violates one of the most fundamental principles of international fair trial standards, and is a violation of the International Covenant on Civil and Political Rights, which is a sort of foundational document in this area. You cannot convict people of a crime without giving them an opportunity to answer their accusers, basically. Even though they're the ones who are avoiding it, of course. So when you do trials in absentia, which happened down at Nuremberg, Martin Bormann was tried in absentia. He was not in the courtroom. Was tried and convicted. Today, and the same thing happened with Pol Pot in 1979. He was convicted in that trial that I showed you photos of. What happens today is quite different. Some of the tribunals have special procedures for in absentia proceedings. However, if the accused person is ever taken into custody, you start all over and you have to have a trial. So so with the special tribunal for Lebanon, they just began their first in absentia proceeding last week. That has a political value, it has a symbolic value, and in a sense it's an act of desperation. They really are concerned that they will never get their accused persons in custody because they're being protected in Lebanon or Syria or wherever. That court focuses on the Hariri assassination and a number of other political assassinations. So you have had there was one in absentia proceeding at the ICTR, I think. But again, they will come up with a verdict, but it's not a verdict that can be the basis of a real criminal conviction because of the problem of fair trial standards. So if the person is never taken into custody, that stands as a conviction in a symbolic sense. They've been found guilty in a trial, but they weren't there. And so, as I said, if they are apprehended, then you have to have a real trial. Does that sort of answer your question? About the ICC, I know you're thinking, so go ahead and think for a minute. Let me just say one other thing. About the ICC, which you asked about, I don't think they would ever do it unless they thought they were never going to get the person.
So what effect does that have on basically accountability in general?
Well, I think it depends on how you define accountability. Accountability in the strict legal sense is putting somebody on trial, and if they're guilty, convicting them and punishing them. You can't punish a person you don't have custody over. So then what you're really asking, I think, is what is the message that is sent if you do an in absentia proceeding? And I think there's two ways of looking at it. One is it shows that international justice doesn't have any teeth. And the other way of looking at it is that it has a political value that makes that exercise worthwhile because it's a way of trying to build political will. This person who's been accused has now been convicted by an international court. So why are various countries not cooperating in trying to arrest that person and bring them before the court? So there's different ways of looking at the value of it, and do we have empirical evidence? No. So you can make arguments either way.
make a quick announcement, thanking everybody for coming again. David's graciously agreed to give a colloquium tomorrow morning in Newberger Hall, room 407, which is kind of next door to the English department. There's going to be coffee and nosh and things to chew on while we sit around the table in a more seminar discussion-oriented fashion. If you want to do the reading, go to the Portland Center for Public Humanities website, click on events, and you'll find the Cohen colloquium and a link directly to one of Professor Cohen's articles. But even if you don't do the reading, please come because it's been a great discussion. And again, thank you for coming, and please join me in thanking you.
Thank you for all the great questions. You really answered, you really asked all the right questions, whether or not I could answer them.